Labor laws govern the workplace. Laws that govern the workplace are often referred to as labor or employment laws. Labor laws are designed to give employees certain rights and to protect them from unfair treatment. It is important that you understand your rights and responsibilities under labor laws. Laws about pay. In 1938, the federal government passed the Fair Labor Standards Act, or FLSA. This law had several requirements. Minimum wage. The FLSA requires employers to pay a minimum wage, which is the lowest hourly wage that an employer can legally pay for a worker's services. Lawmakers change the rate periodically to keep up with inflation. Most states also set a minimum wage. When there is a difference between the federal and state minimum wage, employers must pay the higher rate. The 40-hour work week. The FLSA set the work week as 40 hours. It established overtime pay for hourly workers who work more than 40 hours a week. In some states, employees can receive additional wages or compensatory time, which is time off from work rather than money for working overtime. Employees must agree to compensatory time before they work overtime. Compensatory time is against the law in some states, or for certain types of employees. Child labor. The FLSA also included child labor laws. More recently than 100 years ago, many of the U.S. child factory workers worked 60 hours a week under dangerous conditions. To put an end to such practices, the FLSA set the minimum age for most non-agricultural jobs at 16. Restrictions also apply to the hours and types of jobs that workers under 18 can do. The right to organize. In another effort to protect people who work, the Wagner Act of 1935 made it legal to organize labor unions and engage in union activities. The Wagner Act established the National Labor Relations Board, or NLRB, an independent judicial agency of the U.S. government. The NLRB protects workers who wish to be unionized and investigates charges of unfair labor practices. These unfair practices include interfering with, restraining, or firing employees because they wish to form or join a union. Labor unions. Labor unions represent workers in their dealings with employers. The workers elect union leaders who negotiate for job improvements or change through collective bargaining. Collective bargaining is a process through which unions use the power of their numbers, the workers in the union, to negotiate with company management. They negotiate for such things as pensions, wages and salaries, benefits, and working conditions. If an agreement is not reached, the union may use its most powerful tool, a strike. A strike occurs when workers stop working in an effort to force an employer to agree to the union's terms. Most unions maintain strike funds, which provide partial salaries to workers when they are on strike. When an agreement is reached, the company signs a legal agreement called a labor contract. This agreement specifies wages, work hours, working conditions, benefits, and grievance procedures. The union members must approve the contract before it goes into effect. Before you join a union, you should consider a number of factors. Think about membership cost, track record, or what the union has done for its workers in the past, and membership benefits, such as health care and pension plans, unemployment insurance, and family leave. State laws provide for unemployment insurance, which offers financial and other help to workers who lose their jobs. Sometimes accidents, illnesses, or family responsibilities make it temporarily difficult for people to work. In such cases, workers need to know that they will not lose their jobs. To meet this need, Congress passed the Family and Medical Leave Act in 1993. This law applies to employers at companies with more than 50 employees. It guarantees workers up to 12 weeks of leave for personal medical care or to care for a family member, such as a spouse or a child. Laws about immigrant workers. Non-citizens who are living in our country without authorization from the government are called illegal immigrants. The Immigration Reform and Control Act of 1990 was designed to combat illegal immigration. Employers must make sure that all new employees have proper working papers and identification. Businesses can face fines if they break immigration laws, and workers who are in the United States illegally can be deported. Many states have their own laws regarding illegal immigration, and immigration reform is an issue that is constantly being addressed by federal and local lawmakers. Laws about discrimination. Under laws passed by Congress, it is illegal for employers to engage in discrimination. These laws prohibit unequal treatment based on age, disability status, race, national origin, religion, or gender. Major anti-discrimination laws. The following state and federal laws help to guarantee that every employee has a legal right to fair treatment in the workplace. The Civil Rights Act of 1964 bans discrimination in employment based on race, color, religion, gender, or national origin. The Age Discrimination Act of 1967 makes it illegal to discriminate against people aged 40 and older. The Rehabilitation Act of 1973 and the Americans with Disabilities Act of 1990 protects the rights of individuals with disabilities. Disabilities are long-lasting impairments of the body and the mind that limit major life activities. These two acts make sure that employers provide aids such as wheelchair ramps and other job accommodations so that disabled workers can do their jobs. Many schools and government agencies practice affirmative action. Affirmative action is a policy that aims to increase the number of people who represent traditionally underrepresented groups in a field or a workplace. Traditionally underrepresented groups may include people of color, women, and those with disabilities. Equal opportunity for women and men. In the past, women have had fewer career choices than men. Today, both men and women can choose any career they wish. The Equal Pay Act of 1963 requires equal pay for equal work. Sexual harassment. Any unwelcome behavior of a sexual nature is referred to as sexual harassment. Such behavior may include jokes, gestures, repeated or threatening requests for dates, or unwanted touching. Males and females can be victims of sexual harassment. What should you do if you think you are the victim of sexual harassment? Here are some suggestions. Immediately tell the person to stop. Be clear and direct. Write down what happened, noting the date, time, and place. Include the names of any witnesses and comments about how the harassment affected your work. Inform a trusted supervisor or human resource representative of the incident and follow up. If the issue is not resolved within your company, you can get help from your local Human Rights Office or the Office of the U.S. Equal Employment Opportunity Commission.